Before I proceed, I just want to clarify, it is still 7 people from the NZYQ cohort who are convicted of murder, wasn't it? I heard Mr Thomas have some updated figures, I think, in response to Senator Roberts before. I just want to make sure it's still 7. Mr Thomas, is it still 7 former murderers who are released in the NZYQ cohort?
Yes, Senator. At the 30th of April, 7 murder or attempted murder.
Thank you. And just on those other categories that I'm going to ask about in a second, it was 37 sex offenders, or has that increased?
It's 39 as of the 30th of April.
39, so 2 extra sex offenders. And the 72 people convicted of assault, is that still 72?
That is 73 as of the 30th of April.
Okay, that's increased. The 16 who are convicted of domestic violence and stalking, is it still 16?
That remains 16, Senator.
Okay, 13 who are previously convicted of serious drug offending.
That remains 13, Senator.
And fewer than 5 that were previously convicted of people smuggling and crimes of serious international concern.
That's still less than 5.
Still less than 5. Okay. All right, returning to my question, so to recap, Deputy Commissioner, you said that fewer than 5 of the 7 former murderers are subject to electronic monitoring, so at least 2 are not subject to it. How many of them are subject to a specified curfew?
Less than 5.
Less than 5. So again, at least 2 former murderers who are not even subject to a curfew. I mean, is a curfew a requirement so onerous that we have to release people from it despite the fact they've committed murder?
Sorry, Senator, can you repeat that?
Is a curfew such an onerous requirement that we have to release them from it even though they've been previously convicted of murder? Doesn't strike me, 10 till 5 or whatever it is, doesn't strike me as a particularly tough restriction. We can't even maintain that on former murderers.
I've just referred to my evidence previously, Senator, on this line of questions about the regime, the legal regime that exists and the framework within which the decision makers have to make their decisions. And a particular offence doesn't attract a particular outcome in terms of the decision. There's not a direct correlation in law to say that if somebody's convicted of a particular offence or scale of offence that there has to be a particular condition applied. That's not the way the law is.
I feel like there should be connection between the two, right? I mean, if they're convicted of jaywalking or if they're convicted of murdering, well, that's going to have a different weight, right?
Of course. My point is that there is so much information that the decision makers are taking into account. The offence, of course, is one of those, but it doesn't automatically lead them to an outcome. And these are very experienced people, and the information they've got, though, as I say, can be about, the behaviour of the person while they've been in prison, the behaviour of the person whilst they've been in detention, the behaviour of the person whilst they've actually been in the community, comments around from judges and others about rehabilitation prospects. There's a lot of information, and parole boards operate in exactly the same way, Senator. These are decisions that people make. These decisions that people make, the best decision they can based on all the information they've got, with the sober judgment that they bring to the table.
Okay. Of the 39 sex offenders in the NZYQ cohort, how many are subject to electronic monitoring?
13.
Only 13? So of the majority, 26, are not subject to electronic monitoring of sex offenders. How many of those 26 not monitored are former child sex offenders?
Oh, I don't have that breakdown, Senator. I'd need to provide that to you on notice.
That's extraordinary. 26 former sex offenders, presumably including child sex offenders, are not being electronic monitored and are free in the community. How many of these are subject to a curfew?
12.
Again, so 27 not subject to a curfew. That's like 2/3. How are so many of these people being released from their obligations? This would not meet any public interest test. No one, if you walked out on the street, would be able to make any sense of that.
And the evidence that's been given previously, I'll refer to it again. It's a legal test. This has to be legally robust, this scheme, and what I can say is that the deepest respect for the decision makers and the judgment they bring, and the voluminous information that is provided to them upon which they have to make a decision. But ultimately, the decision has to be based within a legal framework, Senator.
Have any of those 26 or 27 previously convicted of sex offenders, now not monitored or curfewed, committed any other offences, either a state offence or a visa breach?
Oh, I need to take that on notice, Senator.
Okay. All right. Of the 73 people who are convicted of assault, how many are subject to electronic monitoring?
45.
How many are subject to a curfew?
38.
This has got to be one of the most lax community safety regimes ever put in place, when such a high proportion of serious violent offenders are not subject to restrictions in the community.
Senator, I fundamentally disagree with you. This regime has to be based on professional judgment, law, facts and information. And if all you're going to look at is an offence in the criminal code as the guide to the outcome, you grossly oversimplified the situation.
Well, that's the only information I have. You're welcome to give me more information.
Well, I've told you what information that people have to take into account.
But you're not sharing it with me or the public. So all I can judge you on is what you will give me.
We're giving you facts, and we're also explaining to you the scheme that operates. But you understand how these schemes operate. You can't just draw a link between an offence and a decision. It is not that simple. It takes hours to make these decisions.
No, don't doubt that for a moment. But if you want to reassure me and forget about me, the public who will be aware of this, I'd suggest it would be a very good idea to put on the public record what the other factors are, the extenuating factors that would allow you, murderers and rapists released into the community who should otherwise not be here because they are unlawful non-citizens, to be released from the minimal restrictions applied to them.
Go through them. Read them out.
So, Senator Patterson, the factors to consider in making a determination on appropriate visa conditions include the immigration history, if they've been in detention as an immigration detention or custodial corrections, their behaviour and incidents whilst in custody, either our custody or corrective services. The delegate is also provided with information from the Status Resolution Support Service. We also consider medical and health information. If they are subject to community-based orders such as probation or parole, those conditions are shared with the delegate. The compliance in relation to those conditions is also provided to the delegate. We also have information if there's other intervention orders like domestic violence orders or apprehended violence orders. Those conditions and compliance of same are provided to the delegate. If they're employed, the employment is verified. The accommodation where they're residing is also verified. We also, if possible, and through consent, can speak to family members to ensure that there is enough support holistically for these BVR holders in the community to ensure that they are compliant. If they are not compliant, for example, if there's curfew breaches, there is an escalation process that the Department and Operation Aegis officers routinely and actively monitor the conditions. So the escalation point and triggers for a delegate to consider or reconsider conditions is very swift based on the compliance of the individual. So conditions can change if further information is provided to the delegate, and they can take that further information into account and consider the appropriateness of the conditions.
The other thing, Senator, I would wish to add to this is that, unlike with the probably 15,000 parolees that are released from prison every quarter in Australia, this 150 people, we have a dedicated team in each state and territory working on the ground, Operation Aegis, to monitor their compliance with the conditions. And there is both random and targeted checking going on. Those officers on the ground have established relationships with state and territory police. We have Australian Federal Police embedded in Operation Aegis. So for 150 people, there's remarkable apparatus in place to do the best we can to protect our community.
But despite that, Commissioner, at least 29 of them have committed state offences and 5 of them have committed federal offences. That's a recidivism rate of over 20% in just 6 months in the community. I mean, that's way in excess of what it would be in the rest of the population.
Well, parolees is over 40%, Senator, by the way.
Oh, in 6 months?
Over 2 years. 40,
yeah, so it's
over
a different
40% over
point.
2 years.
So we've got 20%, despite all the resources and all the monitoring, they're reoffending against the Australian community and being released from their obligations and the protections for the community, including electronic monitoring curfews.
If you think about the layers of protection we've got in place for these 150 people, it's significant. All the way from the Community Protection Board, the delegates, the mandatory decisions, the voluntary decisions, the monitoring that's going on, the random
Or the monitoring that's not going on. It's not significant if it's not...
There's significant monitoring going on, Senator.
Well, it doesn't sound like it. They've been released from those obligations.
There are random checks in terms of curfews. There are targeted checks.
Some of them are not subject to curfews.
There are weekly meetings with State and Territory Police, daily phone calls. There's a lot going on to monitor compliance of this group, Senator.
Okay.
And I can tell you, it's unprecedented in my experience.
Okay.
For 150 people.
Thank you. The legislation that the Parliament passed to impose these conditions, to give the Minister the power to impose these conditions, requires, and I quote, each of the following conditions must be imposed by the Minister unless the Minister is satisfied that it is not reasonably necessary to impose that condition for the protection of any part of the Australian community. Is it seriously your contention that it is not necessary to protect any part of the community from sex offenders and murderers and other violent criminals to at least have electronic monitoring or curfew? It's not necessary?
Well, the word used is reasonably necessary. It's a legal term and we have to comply with the law in terms of what that means.
Well, I mean, it doesn't look like that has been done very well, given that at least 4 of them not being electronically monitored and 3 of them not subject to curfews, or the other way around, I forget now, have reoffended in the community. Well,
Senator, with the legal regime we've got, we have to make the decision based on the information that's available to us, which is the best gauge we've got as to the future behaviour of individual people. And of course, people don't always conform with predictions in terms of how they're going to behave. I would accept that. It's not infallible. Nobody can come up with an infallible process here. And even if you electronically monitored and curfewed all of these people, they may well still be reoffending. Because the electronic tag doesn't actually give something electric, as you know, electric shock when they do something wrong.
I'm not suggesting
it's not a panacea, Senator. I would accept that. But in terms of the protections that are in place, they are significant. But the decision makers, though, do have to be cognizant of the fact that their decision could be overturned in court, and they have to be thinking about what's the judicious approach to take, balancing, of course, the needs of the community for safety and the information that's in front of them. And the fact that somebody's committed an offence doesn't necessarily mean that they're going to reoffend.
Well, we know in the categories of some of these offences,
one last question,
like sexual offences. We know in some of these offences, in particularly sex offences and especially child sex offenders, that reoffending is very common, very common.
And this is why we have a clinical psychologist and people like that on the Protection Board.
Well, the Prime Minister doesn't think they're doing a good job.
Thank you, Senator Patterson. We will come back to you.